Three restarts. Three restarts. How I suffer for my art. All right. Hello again. This is Ben Hitchcock cross-talking to you today. I have a short update. It has to be very short. I have to be at jury duty in 30 minutes. Don't count me on this, please. Here. But I'm going to speak fast and hopefully to the point. My only jury duty update gossip is simply this. I was at a call to voir dire yesterday, and I sort of recognized the defense attorney. It took me a while. I couldn't quite see her from across the room. And the judge said that somebody recognized somebody's name and yada, yada. And it turned out that I went to law school with her and took criminal class from her, which was all fine and dandy until about halfway through the whole process. The judge reminded me or informed me that the prosecutor was also a former colleague of mine at law school. And I didn't recognize him because he had a huge beard. Anyways, what are the odds? So I thought that was pretty amusing. But also on the subject of bias, I also, because we're going to hear this today, I had to tell the judge, which is true. I know both these people. I didn't socialize with them, but nevertheless, I can do my duty, I feel. But if there's an issue, maybe somebody else is better for the job. But I took an oath to be an attorney and to do that duty. So I can't just say, well, I don't really feel like it. That is one of the things that, judges or whatever have this problem that they're in. Now, on to the main news. Teresa Folaron's canceled hearing, or postponed, or no, it's canceled was the word he used, by Peter Reinhardt. Where are we on that case? I recall that we had, how best to put this? I shared with you that there was probably going to be some issues finding a judge with that one. As I explained to them quite some time ago, and let's not forget that this issue is not new. They just keep ignoring it because of I raised the issue of I'm sorry, the head of their organization, which is Amy Petchacek, and holding her as a witness. They didn't have any problem with that, but now all of a sudden they're having some problems, but all right. So I guess I'll just go through the story. Number one, Peter Reinhardt excused himself. Then Maria Seltzer, let's remember this, put a name to an action here, a face to an action. It's Maria Seltzer. It's not just random or anything like that. She's assigning names here. She's always, so when you get a case, you have a pretty good idea that there's some reason the person's in Madison, the person's not in Madison, the person has familiarity with these people, the person doesn't have. There's all sorts of agency reasons why they may give a specific hearing examiner in that case. Okay, so and we have a statement from her on that, which we will get to. So it was sent to Laura Amundsen here, and I'm just paraphrasing from the notes, but it's basically Maria Seltzer then took Laura Amundsen off the case. This is before we knew she was on the case. We were like, great, she's awesome. Let's go for that. We started researching into her, who she is. I like dealing with her, etc. Then Maria Seltzer took her off the case, and what the notes say is that she only does hearings via WebEx. So because the hearing is in person, she's not going to be the ALJ. Now, I don't recall anything in the recusal powers of that allow an ALJ to remove themselves because they don't want to do that. I don't recall anything along those lines. And it does seem to me kind of like, how is that ALJ doing their job if they're not able to do in-person hearings? Because let's remember, the law says that the hearings are supposed to be in person unless the parties agree. So it kind of seems like that's a problematic position for an ALJ to take, post-COVID or not post-COVID, remote worker or not remote worker. Some things are essential to the job, like, for example, being there. That's just my opinion, and I'm sure and I can see that the state of Wisconsin has other issues, but I don't think it's fair for us to lose the opportunity to have a case in front of Laura Amundsen because we also want to have the witnesses come in person. Doesn't make sense to us. But okay. So then the case was immediately assigned to Benitez Morgan, who apparently says that she said that she read the case file, and based on the case file, she decided that Calvin Furman, that she couldn't do it. So she wrote a order of recusal that is nearly identical to Calvin Furman's, to Peter Reinhardt's order of recusal. I may have it here. And that, I think, is it's the fact that Benitez Morgan took more or less the same language from the where is it? There it is. Here, the complainant has stated an intention to call ALJ Furman as a witness in her case. The undersigned ALJ interacts regularly with ALJ Furman in the course of his duties and views him as a trustworthy and honest colleague. And it's that there, it's my recollection, I'm sorry I only have Reinhardt's one in front of me, that it's that same use of trustworthy and honest colleague, give him great weight, personally biased, the appearance of bias, and so forth. It's literally verbatim, if not verbatim. Anyways, yeah, so that is where I think I'm, that was Laura Benitez Morgan. She was gone, and then we were on Stephanie Brown. Stephanie Brown, I think, was problematic in several ways, mostly because of her appearance on the Debbie Keither case and versus MPS, the Garcia-Hoven versus MPS, the fact that the Garcia-Hoven per probable cause, so there was 2 cases, and for some reason the probable cause determination came out on the day of the last day of the hearing. For some reason, although we've been asked and promised it for about 8 months, for some reason, which would have been too late for us to consolidate. And then when Mr. Garcia-Hoven got COVID and was unable to appear, and we wanted to continue to another day all of a sudden and ask for continuation, all of a sudden there was a big problem. And also, that's the same Stephanie Brown who we don't have a decision on Garcia-Hoven, even though that hearing was more than a year ago. So she then, and I have here, and we can read that, because it's always good to go to primary sources. This is from Stephanie Brown to Maria Seltzer on 4/29 on 1:12 p.m. Now, one thing I'll note is there's nothing copied to the parties at all. But I think this is a peek into how things are operating here. Maria, I reviewed the file for this case, which you assigned to me on Friday, April 26th. I think there's a little bit of wagon circling here, because let's remember the ALJs meet and discuss their cases once a week. I noticed that on April 18th, she just happened to. Complainant's counsel, Ben Hitchcock Cross, informed Peter Reinhardt, the administrative law judge, then assigned to this case for hearing, that the complainant, thank you for bearing with me there. It's my belief, based on information that I have and the fact that many decisions come somewhat around 4:30 on Friday, that I get like sort of let's get Ben decisions, that their weekly meetings are occurring on Friday afternoons. And just based on this letter as well. Okay. The administrative law judge then assigned to this case for hearing that the complainant intended to call administrative law judge Calvin Furman as a witness for the upcoming hearing. Also could be said former employee of Milwaukee Public Schools. As you know, Calvin Furman is a colleague. That is a very suspicious statement, in my opinion. Who is the audience of this letter? Who is it stated that sorry, I'm not going to put it up just because I don't have time. So if we want it, we can, but I don't have time now. But it's directed at Maria Selsor and no one else. But as you know, Calvin Furman is a colleague. Who is that statement for? Is that really to Maria or possibly somebody else? While I believe that I can hold a fair and impartial hearing for the parties, I also believe, see, there's that statement again that I echoed yesterday, nearly at the same time. I also believe that there is an appearance of a conflict or bias because I would be considering evidence provided by my colleague when issuing my decision for this case. Therefore, I am recused. And by the way, there's no mention again of the issues that the fact that Calvin Furman is being represented by MPS's attorney. I want to put that another way. MPS's attorney is representing Calvin Furman with regard to the Debbie Keith case. Okay. Therefore, I am recusing myself from this case pursuant to 218.16 Wisconsin Administrative Code disqualification, Stephanie Brown. Okay. Now, the notes then just say unassigned in abeyance and then assigned to John Carlson. So Stephanie Brown doesn't even bother to tell the parties. The ERD doesn't even bother to tell the parties. It's just something that's put in the case file there that says unassigned and then reassigned. So that's where we're at. Started with Reinhardt. Then we went to Amundsen. Then we're at Laura Benitez Morgan. Then we're at Stephanie Brown. And now we're at Carlson. Oh, how could I forget? We have an email from Selsor on this subject. So let's just read that too, so we can be very clear on what the ERD says. Good afternoon, parties. This is me after I wrote to her saying, what's the status here? After ALJ Reinhardt's recusal, I attempted, man, it's tough being a supervisor these days, to reassign the case to ALJ Laura Amundsen. But she noted that the hearings was set to be in person, and she is unable to conduct in-person hearings, she asked the case to be reassigned. Again, I don't know if that's a grounds for having the case reassigned, but okay. Because again, who is your judge? Who are you arguing to? Are you arguing to all of them? Are you arguing to one of them? Or does it get to change whenever they want? Who are you arguing to? Who is the judge, so-called, of the case, the examiner of the case? Again, it's not a diss. There's one word in the statute. There's another word in the rule. Okay. She recused on the same day because ALJ Furman is named as a witness. I then assigned the case to ALJ Brown. I don't know if she has had a chance to review the file yet. If either party feels it would be appropriate to file a motion requesting ALJ's recusal based on ALJ Furman being called as a witness, parentheses, or any other reason, close parentheses, they are, of course, free to do so. The decision whether to recuse is up to the ALJ. Sincerely, Maria Selsor. Okay, Bureau Director of Hearings and Mediations and Administrative Law Judge, Equal Rights Division, Wisconsin Department of Workforce Development. So, that is, we'll see. I don't know. It seems like they're going through all the steps for some reason. It's not clear to me. It's certainly not obvious to me why they would be doing that. But here we are going through all the steps for some reason. So isn't that fun for us? Yeah. Hey, stick with us. We'll keep you informed.